the first codified law in this country wherein the arbitration procedure was encouraged. Now, after that, lot of problems took place in the 1940 Act working. In fact, there is a very famous judgment of the Honorable Supreme Court in the year 1981, wherein it has been said by the Supreme Court that unfortunately the manner in which courts have started interfering in arbitration matters, the lawyers are laughing and the legal philosophers are weeping. I mean, so the entire purpose had been defeated. So thereafter, we adopted the ancestral model law, wherein the 1996 came into effect. But whenever a law is framed, it has its sets of problems. When it comes to the ground reality in the courts of law or in arbitration process, you find that there are a lot of loopholes which have to be plugged in. So 1996 Act also had a lot of problems. So therefore, 2015 amendment came, which carried out some very drastic amendments. Then 2015 also was felt that it is not perhaps fulfilling the requirements what are expected to encourage ADR. So 2019 amendment came. So I'll be briefly touching in a very, very simple way to tell you this is the broad contour of the subject which we are now going to tell. So my topic here today is about the scope of interference in the awards. So obviously when we talk of interference, the necessary sine qua non is that you are talking about the first relationship which is established between the award, that is the judgment passed by an arbitral tribunal, whether when it is a situation of enforcement of an award in the international award or a domestic tribunal award. But that is the starting point where for the first time the psyche, the philosophy of law, insofar as courts are concerned, that is the starting point. So, when we talk of that, yesterday I had attended the inaugural session, and Justice Thakur, who gave his address, there are 2-3 things which I think were very, very fundamental issues which he raised. First thing which he said was that judicial support is needed for the awards. Now that is something which is very, very important. Second, he said that for encouraging ADRs, we must understand that the courts are overstressed. Now that is another important aspect, that it is an alternative dispute resolution mechanism. Now it has come, according to me, the word alternative is losing its significance with passage of time. I say that it is an alternative because the regular courts are the main structure in the judicial hierarchy in our country. But the way I look at arbitration, that it is the future of the dispute resolution mechanism in the entire world. What to say of India? And India, according to me, must become a global leader in this dispute resolution mechanism. Because the era of ADR, I mean the era of alternative is gradually, the dividing line is becoming very, very thin. It is virtually now a parallel legal system, and a very, very successful parallel legal system, which is playing a very, very dominant and key role in the dispensation and the adjudication of the disputes between so many parties, and especially the commercial matters. Everybody is now opting for the mechanism by the process of arbitration. Justice Thakur also emphasized that despite the fact that the grounds of challenge in an arbitration award are very limited, but still the courts are flooded with litigation. Now I'll be touching on that topic a little ahead in my talk. But that is a very important limb to be understood by all of us, that the approach with which the court sees an award is of paramount importance, and which, according to me, it is the duty of all lawyers and everybody who is associated with this alternative dispute resolution mechanism to put forward your point of view before the court, that the tribunal has to be encouraged, and how the law has to, until unless that law is developed with the cooperation of the court, it will be very, very difficult to really give shape to the purpose and essence of arbitration.